Ninth Amendment to the U.S. Constitution states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people."
James Madison gathered suggestions from all over the first 13 states, and he had a whole list of things that could be included in the Bill of Rights. Many of them were good, and he thought they had merit, but he couldn't see that actually being named. But he realized that as a free people, we have a lot of rights that the government should stay away from, that we as individuals should be protected from those rights from government interference. So he drafted a Ninth Amendment, which basically says the rights of the people are not affected by the fact that we've listed these other rights. And so anything that is the right of the people stays with the people, even though not listed here. And so the purpose of the Ninth Amendment is just to make clear that there may be other rights out there in the universe that we haven't listed in the Bill of Rights.
For 175 years, this amendment received little, if any, attention in the courts. Its meaning remained obscure, and questions about which unenumerated rights it was designed to protect or how to identify those rights went unanswered. In 1973, the U.S. Supreme Court would decide a seminal case involving the Ninth Amendment. The decision would provoke more passion and debate than perhaps any other in the court's history. In 1969, a 21-year-old Texas woman named Norma McCorvey discovered she was pregnant. At the time, Texas, along with several other states, had a law which prohibited a woman from obtaining an abortion except in cases where the mother's life was in danger. McCorvey was soon referred to attorneys Linda Coffey and Sarah Weddington. Using the pseudonym of Jane Roe, McCorvey filed a class action suit in a U.S. District Court in Dallas against Henry Wade, the district attorney of Dallas County. Her suit was filed on behalf of herself and all other women similarly situated. In her lawsuit, Jane Roe contended that she wanted to terminate her pregnancy by an abortion performed by a competent licensed physician under safe clinical conditions. She sought a declaratory judgment that the Texas law was unconstitutional and an injunction restraining the district attorney from enforcing the law. Her case went before a 3-judge district court.
The district court in Dallas said that her right of privacy is found in the Ninth Amendment and found in the 14th Amendment.
So the lower court then has said, we'll only give a declaratory judgment. That is, we'll say this law is no good, but we're not going to give any order to the state to say, stop doing that.
Roe then appealed the judgment denying the injunction directly to the U.S. Supreme Court. At the same time, Henry Wade cross-appealed to the U.S. Supreme Court the judgment declaring Texas's abortion law unconstitutional.
So the Supreme Court is looking at 2 questions. One question of, is there something in the Constitution, either the Ninth Amendment or something else, that supports this notion of a right to privacy that includes this abortion decision? And they're also looking at, can they order the states to stop enforcing this criminal law?
Norma, essentially what she said was, the state making this law prohibiting me from having an abortion violates my right of privacy. And the state of Texas argued that the state has a very compelling, important reason for wanting to protect the life of the unborn, and that this reason gives the state the right to pass this law. So again, in Roe v. Wade, what we have, as we saw in Baker versus Carr, we have 2 important philosophical approaches that both deserve consideration.
On January 22, 1973, by a 7-2 vote, the U.S. Supreme Court ruled in favor of Jane Roe, upholding the district court's judgment declaring the Texas abortion law unconstitutional.
In Roe v. Wade, the court said, we find that the right of privacy is located in the 14th Amendment due process clause. They gave a head nod to the Ninth Amendment, saying that whether it's in the 9th Amendment or the 14th Amendment is subject to discussion, but we're holding that's within the 14th Amendment.
Justice Harry Blackmun wrote the majority opinion for the court, saying that although the U.S. Constitution does not explicitly mention a right to privacy,
the court has recognized that a right of personal privacy, or a guarantee of certain areas of zones of privacy, does exist under the Constitution. The 9th Amendment's reservation of rights to the people is broad enough to encompass a woman's decision whether or not to terminate her pregnancy.
So the Supreme Court acknowledges a constitutional zone of privacy that's protected under the 14th Amendment. And if the state is going to go intrude into that zone of privacy, it has to have one of these compelling state interests, because they don't say, well, that the state's interest is nothing. They acknowledge that it's significant, but they need to balance it. So Justice Blackmun decides that one way to balance it is through this trimester approach.
The trimester test is a function of trying to accommodate the important philosophical arguments made by the state of Texas. The state of Texas said, we have the right to regulate this procedure. We have to protect the unborn. And so the court said it's a strong argument, and the state is correct. It has an interest in the unborn. But the court said that interest doesn't begin at conception.
In the first trimester, the fetus doesn't have the ability to survive outside of the womb. So in the first trimester, he said, the woman's interest in her making this decision, whether or not to bear a child, predominates. And so the state's interests cannot overwhelm that. They cannot prohibit her from making that decision.
The second trimester was the court saying there comes a point where an abortion would be more dangerous to a woman than in the first trimester, because the fetus is more developed. It'll be requiring more medical supervision. And therefore, the state has an interest in making sure that those abortions performed during the second trimester be done under certain procedures, like perhaps in a hospital or with a doctor in attendance. So the second trimester basically was the court saying it's okay for the state to regulate how an abortion is performed in the second trimester, not in the first. No regulation at all. Maybe in the second, yes, and the state has a lot of control in the third.
In the third trimester, according to Justice Blackmun, the state's interest in protecting potential life, which is now potentially viable, could possibly live outside the womb, and where a late-term abortion is dangerous, much more dangerous. They say that in that last trimester, the state's compelling state interest in potential life becomes sufficiently compelling to trump the woman's interest. And they can absolutely deny her an abortion.
So the court was saying the right of privacy is not absolute. There comes a point where the fetus is viable, can live, and that's when the state can be involved in deciding whether a woman can have an abortion. Now, the court had the possibility in Roe to say that from the moment of conception, an embryo is a person under the Constitution. The court said there is absolutely no precedent that says that a fetus, even right before birth, is a person. Our law doesn't recognize that. So that's been changed somewhat over time. But, so the court held to the notion that no, until a person, you are not legally a person by law until you're born.
The Constitution does not define person in so many words. The use of the word is such that it has application only postnatally. This persuades us that the word person, as used in the 14th Amendment, does not include the unborn.
Justice Byron White, along with Justice William Rehnquist, each authored a dissenting opinion. Justice White considered the majority opinion, quote, an extravagant exercise of the power of judicial review. In his dissent, he wrote,
I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant mothers, and with scarcely any reason or authority for its action, invests that right with sufficient substance to override most existing state abortion statutes.
What he was saying is that the court is taking this vague term called due process of law, and it's converting it into a system by which judges get to decide what is a fundamental right. And he said that's giving to us, the judges, the ultimate power to decide what a government can and cannot do. A power that's not articulated with any specificity within the Constitution.
Justice Rehnquist, elaborating on Justice White's dissent, criticized the trimester test. He wrote,
The decision here to break pregnancy into 3 distinct terms and to outline the permissible restrictions the state may impose in each one, for example, partakes more of judicial legislation than it does of a determination of the intent of the drafters of the 14th Amendment.
He very much was in the school of there is no content to the due process clause. It is procedural. Judges don't sit here as some kind of wise group of philosophers who decide what our society should and should not protect. It's the people of the United States who make that decision. And they are the ones who speak through their legislative body and who pass laws. And this law was passed by the state of Texas, representatives of the people, and they said no abortion unless the life of the mother is threatened. We shouldn't decide otherwise. That's not the role of judges.
It becomes a debate about how you find rights in the Constitution, how you identify them. And when courts, federal courts, find those rights, what are they doing? Are they actually reaching out to protect our most sacred liberties? Or are they grabbing power for themselves to make decisions about things that ought to be voted on?
Although the 1973 Supreme Court decision in Roe v. Wade made abortion legal in all 50 states, the debate over whether or not abortion is a constitutionally protected right continues, with advocates and opponents each claiming their view is supported by the Constitution.